Welcome to our third and last lecture on the Supreme Court today. Our speaker today, Jack Citrin, has a long Berkeley association. He was a graduate student here, and after getting his PhD here, he joined the faculty in political science and retired just this year as the Heller Professor of Political Science and director of the Institute of Governmental Studies. And then he received the Berkeley citation. Now he is Emeritus Professor of Political Science. His research centers on American politics and the bonds often fraying between citizens and leaders. In this context, he studies political opinion, political trust, and most recently, issues of national identity, immigration, and policies toward demographic and cultural diversity. His latest book, entitled American Identity and the Politics of Multiculturalism, was reviewed as a book, quote, worth waiting for, a rare mixture of theoretical guidance and respect for facts. Other leading works by Jack Citrin are Tax Revolt, Something for Nothing in California Public Opinion and Constitutional Controversy, and another book, Evolution and Revolution in the Presidential Nomination Process, 2008 and Beyond. His numerous articles have won prizes from the American Political Science Association, and this year the International Society for Political Psychology honored him with the prestigious Laswell Award for Distinguished Scientific Contributions to Political Psychology. And today he's going to speak to us about the Supreme Court in the People's Court. Jack Citrin.
Thank you, Louise, for that generous introduction, which I wrote myself. It's really a pleasure to be here. This is my first formal speech or address or lecture or work, as it were, since I retired on July 1, and so I'm a little out of practice, but I'll do my best. And of course, coming to this room, first of all, I see some friends from diverse aspects of my career here. I won't name all of you, but thank you very much for coming, and it's nice to see everybody here. This room, as some of you know, is the room in which academic senate meetings are held. I assiduously have avoided those meetings for 40 years, except on one or two occasions where I came here and spoke in favor of a motion of no confidence in our then Chancellor, and then castigating our then President Gardner for having the temerity to try and cut down the merit increases that faculty members had earned. And that took me to the real court from the People's Court, and there is a case, Citrin et al. Versus UC Regents, which was decided in favor of the faculty and which guaranteed that since 1991, the powers that be at Moscow Center, which is what I call the office of the president, have not attempted, whatever else they've tried to do, to cut faculty and staff merit increases. So that is my foray from the People's Court into the real courts. And yeah, my wife is always embarrassed when I say things like this, but she's not here. So let me just begin and just start talking about sort of putting this. I'm not like Jesse Chopra or Amanda Tyler, who spoke here before. I'm not a lawyer. They're distinguished lawyers. They know about the intricacies of the Supreme Court, what goes on there. Jesse, after all, clerked for Earl Warren. Amanda, I think, also clerked for a Supreme Court justice. So they know the nitty-gritty and what goes on. I take a sort of a more bird's-eye view of this and want to look at where does the Supreme Court fit in the American political system, and in particular in a democratic political system, because the role of the court is in some ways anomalous in that context. There are lawyers in the audience here. Please don't take it too hard on me, but really we have, "Oh, say can you see" is the opening line of our national anthem. I think it should be "see you in court," because this is the mantra of a litigious America. Ironically, the Supreme Court, which sets its own agenda, is hearing fewer cases over recent years, but these, of course, are the big cases. Meanwhile, lower courts are busier than ever. The Supreme Court, then, is at the storm center of American politics, deciding issues that divide the nation and deciding what is law. So an enduring question really is, from the point of view of political scientists, how does the public view the court? And in some sense, what is the court's relationship to public opinion? Because if the Supreme Court tells us what the law is, in a democratic society, there's a contending force that is trying to tell us what the law is, and that is what the public believes as expressed through the electoral process and other processes. Okay, so let me see. I have these slides. I'm not sure which ones they are. See you in court. I said that already. Okay, well, let's go back one. I want to say one thing more. Okay, so are the courts powerful? This is a rhetorical question. But why are they powerful? Not only because of their role in the constitutional system as having the final say, but they're powerful because increasingly the courts are taking on a wide range of cases. I mean, the types of issues that the courts now, not the Supreme Court perhaps, but lower courts take on. Who can you hire or not hire? What can you build on your own property? Can the city of Pittsburgh, or Berkeley for that matter, levy a special tax on students who, take services and pay no taxes? Where can nuclear waste be dumped? And for us, can public pensions be cut? So there are more laws. There are more, the courts themselves, or Congress and the courts, have increased the capacity of individual citizens to sue, so you have more ability to have standing in the courts and bring in all kinds of issues. And we are in a more complicated society, people running up against more and more. So the courts are busier and busier. They take on a wider range of issues. Should they have this power? And this is, of course, a question that people widely disagree about. We want to go back to the origins, and which is the framers in the courts, and the famous Federalist Sum of 78, widely quoted in any political science course. Hamilton, the judiciary, he says, will be the weakest branch of the federal government. Why? The judiciary has no influence over either the sword or the purse, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment. Well, but does that judgment have power? First of all, there is judicial review. Hamilton recognized it's necessary to uphold the Constitution. Once you have the Constitution, you have to have someone to tell you what the Constitution is, and so that is the Supreme Court's role. Okay, Jefferson, of course, disagreed with most of what Hamilton said, and in this case, he felt the courts were too powerful, they were illegitimate. He disagreed with judicial review, and he raised the specter, which is a legitimate specter, which continues to haunt the court, is what if the court is the repository of a counter-majoritarian point of view? That is to say, the court consistently takes action that the majority of the people disagree with. What is the court's sort of future in that situation? Now, who was right? Jefferson or Hamilton? Hamilton and Jefferson? Actually, neither or both. If Hamilton was right and the court is weak, then how come the two most powerful people in the country for the last 20 years were first Sandra Day O'Connor and now Anthony Kennedy? Neither elected, but essentially deciding by being the swing vote on the Supreme Court all of the critical issues. Who elected them? No one elected them. I mean, in some indirect way, they came from public opinion. I'll talk about them in a minute. So Hamilton was right also in saying that with a written constitution, judicial review was necessary. But Jefferson was right in pointing out the problem of a counter-majority in court overriding popular sovereignty. And that poses the fundamental issue in a way from political scientists' point of view, maybe not a lawyer's point of view. What is the legitimacy of the federal judiciary. These are people appointed with lifetime tenure, secure salaries. They're not elected officials. They have enormous power in a democracy. And what I've noticed over time is, black robes seem to add to your life expectancy. I think we should demand this as part of our retirement package. And we wouldn't be worrying so much about the health insurance, Just a black robe, you're going to live for a long time. Okay, so just to summarize this point here. The problems with judicial power. What makes it legitimate in a democracy? What constrains its power? And these questions are intertwined because whatever the short-term goals of judges are strategic political actors. They are not these philosopher kings. Forget that. They not only want to advance what they believe is right policy-wise, but, and this is critical, they want to preserve the legitimacy of the court as an institution, because the legitimacy of the court as an institution is critical to the power of the court. Okay? So let me just say a word or two, sort of technical definition. I'm used to talking to undergraduate students who forget most of what you say, so you have to repeat it over and over again. So legitimacy refers really to what? Belief in the moral authority of an institution. It's the idea that you should obey those in authority, even if it's against your interests, what you think, what you would prefer, presumably because they're acting in accord with the rules of the game. So if an institution or an actor is legitimate, that gives them power. It's a resource. And so how to retain the power and the legitimacy of the Supreme Court has been an ongoing concern of the court from its inception. And two critical issues, which I'll point to relatively recent. The first is the court packing plan of Franklin Delano Roosevelt, where he was unhappy with the court striking down all of New Deal legislation and came up with this plan of, okay, I'm going to just increase the number of judges by 6, and guess who they're going to be for? They're going to be my guys, my women, my guys. At that point, probably my guys. Okay, now Charles Evan Hughes was the Chief Justice of the Supreme Court. He lobbied members of Congress to oppose this privately and also pressured 2 members of the court to change their votes on a couple of key New Deal legislation issues. And so we have this slogan, a switch in time saves 9. Okay? And that was all about the legitimacy of the court. That was all about the legitimacy of the court. Now here we have the most recent example, and probably the really telling example, is Chief Justice Roberts' vote on the Obamacare. 2 separate votes on Obamacare. He saved that legislation from being declared unconstitutional. There's all kinds of gossip, how he changed his mind in the middle of the first vote, how he constructed, and their lawyers here, some kind of somewhat ingenious but unique argument for why the individual mandate was constitutional. But it's pretty clear that his purpose, or one of his purposes, was not to get the Supreme Court in opposition to a president and a Congress who had just passed the president's signature legislation, and the president had already been making noises about his dissatisfaction with the direction of the Supreme Court. So Roberts, who you might say is very conservative, we looked later on at his ideology in some measured way, nonetheless, he wants to be Supreme Court Justice for many years, and he will be because he's a young man, and he's been in other domains also expressing quite publicly his concern about this. So the Supreme Court has a difficult path in the sense it retains its legitimacy. How does it retain its legitimacy and its capacity to implement its decision? And part of this, my argument is, depends on its relationship to public opinion. Its relation to public opinion in 2 senses. One is the general approval, the general support of the public for the Supreme Court, for the courts as an institution, and then how the people react to particular specific decisions on specific policies. Okay, so now I will give you, these are sort of the questions that I hope I'll cover in whole or in part the rest of this talk. What does the public think of the Supreme Court and what counts for variation of this opinion? who are happier with the courts, liberals or conservatives? A sort of surprising answer to that. Yeah. Does the court reflect public opinion? If so, what are the mechanisms for this reflection? And also, once the court makes a decision, does the public care? Does the public follow the court? Most of the argument among political science and from an electoral point of view is, does the court follow public opinion? But does the court shape public opinion? What is kind of reciprocal relationship there? And then, no one can give a talk in American politics today without saying what's the impact of polarization on the judiciary? And then finally, this is a question that I assign every one of my classes. I just say, are judges just politicians in black robes? Comment. So you can think about that. Okay, so let me start with some data on public opinion here and on what we know from multiple polls about public approval of the court. I'll start with a Gallup poll, a series of Gallup polls that have begun before 2000. I'll start in 2002, which is right after Bush-Gore. So you would think that Supreme Court would take a hit after the Bush-Gore decision. But at that time, 62% said they overall approved of the way the court was handling its job, and 25% disapproved. In 2017, in July 2017, it was 47% approval and 45% disapproval. Okay, so there's a swing in the negative direction over the last 2 decades. But, we live in general in an era of mistrust of government, and this is widely known. I'll just cite one example. I'll put some tables on in a minute because I'm a data guy. As an example, in 1964, 76% of the public said they trust the government. They trusted the government to do what is right all or most of the time. Okay, 76%, 1964. 2016, that figure was 22%. So a 52% drop. And this decline was actually relatively steady, and it was across the board. Virtually every social group, every political group, experienced a similar decline. If you look year by year, there are some fluctuations, obviously, but if you look at it in the large, this is what has happened. So let me show some of these figures very quickly here, just to prove to you I'm not making it up. Of course, I could have made it up anyway, but here we go. Okay, so that's the figure I just talked to you about. Just due to percentage trusting government to do right all or most of the time. Now, the government is a kind of abstract concept, so people have asked specifically about Congress, the presidency, and the Supreme Court. Okay. So this is the Supreme Court, executive branch, and U.S. Congress. Just to make a long story short, pretty much a decline everywhere, but Supreme Court is more approved than the executive branch, and Congress is at the bottom of the list. In 2016, only 12% of the American public said they approved of the job Congress was doing, and you have to wonder what that 12% was smoking when they were asked that question. Yeah. Okay. So we got that. Now, this one is, the R should be the D, should be a D there. This just reflects sort of partisan differences, sort of the political reading of the Supreme Court. When the chart is under the 0 line, that means Democrats are more negative than Republicans, and the opposite is the case. And you see, for most of the time, until recently, Democrats were more critical of the Supreme Court than Republicans. There's a very simple explanation for that. Republican presidents were in control. They were appointing the justices. So, that's the way it is. Okay. So, overall then, just sort of, when we analyze these data, what explains approval and disapproval? So I'll give you just some brief inputs. First of all, the Supreme Court, like all public institutions, universities, business, labor, the church, every institution except the military over the last 40 years has suffered a decline in public confidence. So the Supreme Court is not immune from that generalized sentiment, and it's done in some sense better than others. Second thing is, as I just said, partisanship matters, but actually in general, conservatives are more disapproving. They're more suspicious of the court, even though, we tend to think of the court as appointed by mainly Republican presidents or a majority of Republicans as being a, quote, conservative court. Conservatives are more critical than liberals. And why is that? Because they feel they've lost out on major cases that they care about, despite having this majority. Abortion, gay rights, Obamacare, and there are other such examples. But the key thing, if you want to say one explanation, how, if I could make a bet, ask a couple of questions and say, okay, I'm going to predict whether or not you're approving or disapproving of the Supreme Court. It is the discrepancy between your own ideology and your perception of what the court's dominant ideology is. So there is a political, ideological component to it. That perception can actually often be mistaken, inaccurate, but nonetheless, perception beats reality. Okay? Another thing I'd just like to point out, this is not a really important point, except let's not forget that public knowledge of what the Supreme Court is, what it's doing, is pretty limited. Not in this room. Everybody here knows everything. But actually last year, after Roberts had been the Chief Justice for 11 years, only 28% thought he was the Chief Justice, could name him as the Chief Justice. So that tells you that facts are not widespread. This is not unique to the Supreme Court. This is just, ignorance is bliss is the way in which many people believe it. So we have this decline in approval and confidence. But let's go to the deeper issue of legitimacy, because legitimacy speaks to really, do people want the court to be changed? Is there some kind of movement or opposition to the way the court is currently constituted? And here, I'll just give you the results of a recent poll. And this is sort of, people are asked to agree or disagree with this series of questions, which speak to the nature of the Supreme Court and changing it, the counter-majoritarian argument of Jefferson. And when you look at these kinds of more general questions, rather than are you happy or unhappy with what they're doing now, as to what should they be, what should be their role in the political system, you see a much more positive set of answers. Okay, and this is a poll conducted just 2 years ago while the other thing was declining. All right, so we have institutional legitimacy. Here's a summary slide, I hope. Nope, I'll just read it. Institutional legitimacy remains quite strong despite this downward trend in approval, and this is also has endured our current period of political polarization. So as a public opinion researcher, this is a standard warning. You'll get an answer depending on the question that you ask, right? And so there are different ways of measuring support and approval. Okay, so let's now turn to the judges and move on to essentially their political nature and the relationship of what they do to public opinion. Okay, how do judges decide cases? There's one point of view which is, I think, a little naive, which is they look at the legal issues involved in every case, they focus on those legal issues, and they make these decisions on a case-by-case basis. If that were true, then lawyers wouldn't worry so much about who the judges listening to their cases are. In fact, there's something that is more dominant in political science, which is what we call the attitudinal model of judicial decision-making. And what this essentially says is this: judges have ideologies. They have points of view. They come to their position, they come to their offices with these ideologies already, with their points of view already built in. They rarely change those points, basic points of view, and they act on those points of view. I'm going to point out that this is an extreme argument, but it's not that much of an argument. So the law matters, of course. Judges are not ignorant of the law. They refer to the law. But in many sort of value-laden cases where you can find arguments on both sides and the precedents are ambiguous, judges find a way to fit the decision to their personal beliefs. And maybe the best single case of this recently is the Bush versus Gore decision. Okay? The Florida Supreme Court, made mostly of Democrats, made one decision. The U.S. Supreme Court concocted a reason, basically, to reverse that decision. Okay? So a quote, let me quote from a University of Chicago law professor, Eric Posner. He says, trying to find a jurisprudential explanation for opinions on same-sex marriage and affirmative action, for example, is a fool's errand. Same-sex marriage is advancing while affirmative action is receding because that's what the relevant majorities of judges care about. Okay, so here are just some more data here on what you, I think, already know, is that the politics, the political background, the political points of view of judges matter. So let me just go through a bunch of slides here very, very quickly. And there's some interesting things in some of them. First one is this. Oops. Next. Here we go. Okay. So what this is here is locating the judges, and this was done when Justice Stevens rather than Kagan was on the court, putting them in a liberal conservative continuum depending on their decisions on cases that they heard. Okay? And so you have the usual lineup, right? On the right you have the liberals, on the left you have the conservatives. They're ranked in some ways. The really interesting thing about this is that Justice Stevens, who was appointed by a Republican president, Gerald Ford, is more liberal than anybody else. And this was certainly not predicted. And I suspect Ford, was not thrilled. But once you're there and you can't be gotten rid of, you can do your own thing. And in some cases, justices obviously changed their overall orientation. Here we have just proof of the relationship between ideology and how judges act. Okay, this is support for free speech claims on the liberal side and on the conservative side. Okay, and you see justice by justice, and very clearly the conservative justices are more supportive of conservative claims, and the liberal justices are more supportive of liberal claims for free speech. So, that again says something about the sort of politicization or the politics of the court. Here's another one, I think that, this takes it all the way back to Kennedy, and it just says the percentage of liberal decisions by federal district judges, this is now no longer the Supreme Court, according to the president who appointed them, and the Democratic presidents produce justice, appoint judges who are liberal and vice versa. We know all this, but it's always good to back it up by, quantitative data, okay? And then this, I like to show you this one because it is relevant to today. So this goes to, I think 4 or 5 years ago, Supreme Court session. Here, 1, 2, 3, 4, is it 9-3-6-9? 5-4 decisions. Okay? In every single one of those 5-4 decisions, Justice Kennedy was on the majority side. He was deciding vote. And there's a range of topics, death penalty, environment, so forth and so on. The free speech case is one of my favorite cases because this involves a high school student who went to a rally at a school it was in Alaska, and he uncorked a banner which said "Bong hits for Jesus," and claimed that was within his First Amendment rights, but he actually lost that case thanks to Justice Kennedy. Okay, turning one final sort of piece of evidence here, and this speaks to the way in which the appointment of judges has become viewed as more significant and more controversial, and this talks about the decline in the confirmation rate of district court judges over time. This ends in 2005, but it continues, and what it shows is that each judge's nomination is now a political battle, and both sides gear up. And we've had the nuclear option, first applied to circuit court judges, now to the Supreme Court, where the filibuster has been removed. And so if you have a president who has a majority within the Senate, this line will end. But nonetheless, it speaks to the politicization. So let me talk about the attitudinal model, kind of a cynical kind of view of judges. But let me just say that there are some limits to the attitudinal model. First of all, these judges come from somewhere. They're not dropped from the moon or Mars or something like that and become Supreme Court justices. They're appointed, they're nominated, and then they're confirmed, which means there's a relationship between elections and who these judges are. And so, in some sense, judiciary follows the election returns with a bit of a time lag. Because of longevity, no president can be guaranteed that he or she will have the opportunity to nominate Supreme Court justices. Obama nominated 2, and then the Republicans managed to make sure he did nominate his third. On average, I think from Kennedy on, with the exception of Jimmy Carter's one-year term, most presidents have had within their term 2 appointments. And 2 appointments can be significant. And now, of course, we've got at least 3 justices who are, even with their black robes, keeping them going, pretty old. And so we will see what happens with that turnover. Okay? So longevity is there, and also there's a certain amount of unpredictability. I mentioned Stevens earlier, moving from being conservative to liberal, and if you look all the way back to Earl Warren, you see that the Republicans have been less successful in having justices who stay, quote, true to their credo. Harry Blackmun was Republican appointee, key on Roe versus Wade. Kennedy was key on the gay rights issue. Sandra Day O'Connor was a swing vote who went one way or another. Okay, but still, we know pretty much how a judge will vote. For example, on every 5-4 case, I don't know if Jesse Chopra spoke about this, Ginsburg and Kagan have never voted differently on every close case. They were always on the opposite side of Alito and Thomas. Roberts and Sotomayor have never agreed on any 5-4 cases. Okay, so you know that there are these coalitions, and they're pretty stable. So yes, how does the public feel about this? Do they want judges just based upon their legal qualifications? In fact, the public is pretty tuned into this political dimension and is not unhappy with it. When you ask people, should judges during their hearings, the nomination process hearings, should they be asked about their political points of view, 60 to 40 say yes, because they know that that's the reality. So people aren't as dumb as we sometimes make them out to be. Okay, all right. So we've talked about sort of public opinion having an influence in a couple of senses. One is on the selection and confirmation, because it's political actors who are elected who make those appointments. Second of all, the concern for their institutional legitimacy, make the judges themselves kind of attentive to public opinion. And then, of course, moderate justices, people in the middle, are more likely to be swayed by what other people think. And we see this with Sandra Day O'Connor and with Kennedy. And I'll just show you one thing in Kennedy's opinion. He was the key opinion in the same-sex marriage case. And see, just public opinion was moving in that direction, quite surprisingly and quite quickly. And so it was, in some sense, easier to make a decision that one could then say, well, this is what the public will accept or will want. Okay? Let me turn now to, does the Supreme Court influence public opinion? We talked about the indirect ways in which public opinion influences the Supreme Court. But now let's turn this on its head. So here, of course, I quote from the seminal book written by me with two of my former students. Louise mentioned it, Public Opinion and Controversial Controversy. And what we did is we took a whole bunch of controversial issues and cases: abortion, same-sex marriage or gay rights, terrorism, affirmative action, death penalty, flag burning. I can't remember, but there were about 10 of them. And we tracked public opinion both before and after the Supreme Court made its ruling, and tried to figure out in a variety of ways what the impact of that ruling was. And here's two sort of general principles, which if I can pass on. These are, I think, things that we people in public opinion really believe very strongly. First of all, if someone has a strong opinion, you're almost never going to persuade them, period. That's what it is. People hold on to their opinions. They discount information that conflicts with it. They believe information that supports their opinion. So, that's just the way it is. Secondly, you can't persuade people you can't reach. So people never know, never have heard, never what the Supreme Court did or didn't do. You're not going to change their opinion. They probably don't really have a firm opinion to begin with. So those are two sets of people. So ergo, those people who you can change, or who the Supreme Court might influence, are those with relatively weak opinions beforehand, yet who are accessible to new information. Okay? So then, once we knew that, we identified 4 different models, which are listed here. Persuasion, backlash, polarization, stability, which means no change. And I'll just go through them very, very quickly here. The null hypothesis is basically there's no change. Supreme Court acts, public opinion is fundamentally unaffected. And this is really often the case because many decisions of the Supreme Court are obscure, about federal power, for example, which is very complicated. Who knows? Who cares? But even on issues like gender discrimination, affirmative action, where opinions are pretty fixed, right? The net effect of a Supreme Court decision is not to shift opinion because people hold on to what they already began. Okay. Second idea is the idea of the so-called legitimization, or the Supreme Court has often been referred to as a Republican schoolmaster, teaching the people what they should believe, what the law should be. And so, this is rare, where sort of the court's decision shifts opinion in its own direction, but it has happened in a number of cases. I'll mention some cases. One is the Loving case on interracial marriage. I don't know how many of you saw that movie, but after that decision, opinion, which already was moving in that direction, certainly moved quickly to agree that miscegenation laws were unconstitutional. And there also can be a quick shift and then a backlash, which is the case of Roe versus Wade and school desegregation education, Brown, where there's initially a backlash against it, but then shift of opinion in favor of that decision. Okay, so it's also, of course, correlation is not causality, so it's a little hard to identify exactly how much it was the court's decision as opposed to longer-term trends. One of those longer-term trends is people die and are replaced by people with different opinions. Nobody, even the Supreme Court justices, live forever. Okay, so that's number 2. Number 3 is backlash. The court decisions actually creates opposition that can ultimately cause reversal of their original decision. This happened this is the Jeffersonian case. Counter-majoritarian opinion, the public gets exercised, the public mobilizes, Supreme Court sort of says, institutional legitimacy, we better trim our sails a little bit. And I think the best example of this is, it was in the 70s, was death penalty. Death penalty was declared unconstitutional as cruel and unusual punishment. 2 years later, it was now back in force with some, little caveats, but nonetheless. So that's the best case. But now, of course, we have, I think, again, opinion shifting against the death penalty for different reasons. So, over time, things change. And the final model is polarization. And this is where, the court's decision actually divides people, polarizes them more than they were before, or at least reinforces that polarization. And you get partisan differences, very strong partisan differences, even though the decision isn't changed. I'm going to just give you 2 examples of this. School prayer, which the court has repeatedly says unconstitutional, but which a majority of the public continues to want, and which many school districts, I suspect, continue to observe. And then the flag burning is unconstitutional. Flag burning is unconstitutional. Again, that's the law. It's observed pretty much, but it's not popular. There's been a polarization on that. Okay, so that's sort of the issue. Then that talks about the limitations on the Supreme Court's power to change public opinion. So let me just, probably should come to a conclusion and then get some questions. So I've talked, in general, Supreme Court does something and we kind of go along and obey. We hate it, right? Gun rights, whatever. Everyone has their favorite horrible decision, Citizens United, etc. But nonetheless, law proceeds. But in fact, there are constraints on the ability of the court to do exactly what it wants. And we know what they are. The first is sort of what in judicial terms called stare decisis, that is precedent. Courts are really reluctant to completely overturn precedent. Not that they haven't done so. I just talked about cruel and unusual punishment, Supreme and death penalty. That's one case. But Brown versus Board of Education is maybe most famous case. But, it's not a frequent occurrence. Secondly, of course, I've said the public opinion is a constraint. I've talked about that, and I think it's an important constraint. Elections mean that the majority will, over time, shape the Supreme Court, and that reflects public opinion. Third thing is the court doesn't just, cases have to come to the court. They can't just go out, I don't think, maybe lawyers will disagree, and say, hey, we'd like to change the law in this case. They might want that, but they have to kind of wait for cases to come up to them. They can choose what their agenda is, but within limits. And then, of course, there's Congress and the president. They can be threatened. Laws, first of all, can be changed to override some court decisions that are not constitutional. There can be threats of constitutional amendment, very hard, very rare. Impeachment is a threat. And, court packing maybe has not disappeared from the armory of weapons. So the court is cautious of all of these things, and that's a constraint. And finally, the Supreme Court cannot enforce its own decisions by itself. This is Hamilton's point. It doesn't have an army of officials, okay? And there have been at least 2 presidents, Jackson and FDR, who said the Supreme Court has made its decision, now let them enforce it. So the Supreme Court depends on lower courts, other states and officials to support itself. So that's kind of an overview of the court's role in the political system, and in particular in the People's Court. And in the People's Court, the court has a pretty ambiguous position. We've seen that. I mean, people sort of think, yeah, we need a Supreme Court. Yeah, it's important to have them. They should be impartial. But we kind of know they're not impartial. We're not so happy with what they're doing. The liberals aren't happy half the time. Conservatives aren't happy the other half of the time. And so that the implication of that is not so much that the court won't go ahead and make its decisions, but what will be the impact of those decisions? Will a decision such as the abortion decision or the gun rights decision simply open up the door for 20, 30 years of continuing battling in the political realm where nothing is ultimately settled? And that's why public opinion, not just public opinion in general, polls that I've been talking about, but public opinion as shaped by political action is important. Okay, so let me just summarize. How do we describe the Supreme Court? Are they just justices in black robes? I guess I would say there's a pretty good case to be made for that. If a kid in poli-sci 1 said yes, they would get an A- at least. Are they Republican schoolmasters able to shape public opinion in a particular direction? I would say less and less so. Why? Because the court is polarized and the public is polarized. And you can't persuade people who already have very strong opinions. Are they then, if they're politicians in black robes, are they strategic politicians? That is to say, are they behaving strategically to preserve the power of the institution? And I think that's certainly there all the time, and the current Chief Justice is sort of concerned about that. So, what should the Supreme Court do in this situation? How should it protect its legitimacy? And here, there's kind of the debate over how active should the Supreme Court, or should the Supreme Court act in a restrained way and defer to the so-called political branches. So judicial restraint. And that's the current Chief Justice's underlying point of view. You saw that in his decision on Obamacare. And there's an interesting case coming up right now, which is a gerrymandering case in the state of Wisconsin, where my former PhD student Eric McGee is one of the leading experts on the changing of the law. But that would thrust the Supreme Court quite heavily into a very political domain. And that'll be quite an interesting case to see. And once again, we will learn that the most powerful person in America is Anthony Kennedy. Thank you very much.
Good afternoon. My wife and I just got back from a nice trip to Washington, D.C., playing around the museums and so on. And last Monday, had the privilege of sitting on the Supreme Court. Our Airbnb host said that when they were there, Clarence Thomas spent the whole hour or so zonked out. We got there the first hour of the opening day, opening session of the fall. Clarence Thomas was zonked out. It made What you said made me wonder is this just an aberration? Maybe he doesn't get enough sleep, or he has a sleep disorder, or do a lot of the judges just kind of zone out when they hear the arguments and just fall back on their previous prejudices?
Well, I think Thomas is unique in never having spoken an oral argument, or maybe just once. And I know a couple of people, in fact, a couple who are on the faculty here, who have clerked for him, and they simply say that he doesn't believe in the efficacy of the oral argument. He says he will read the briefs, that's where it's made. The oral argument, a lot of it is just showboating, that if someone else makes some penetrating comment, he will listen and maybe pay attention, but he just thinks it's kind of a waste of time. That's what they say. I think the justices vary in their loquacity and in how often they speak. I think Justice Ginsburg also doesn't ask too many questions. Maybe now, I don't know about back in the day, but she does when it's something that she really, really cares about. But, you know, for the most part, she's at the low end of the, if you went every single day for every single session and you counted it up, you know, there'd be obviously some variation. The new Justice Gorsuch, usually the rookies, if you're smart, you know, don't talk too much. He, I guess, likes to talk a little and has been slapped down a couple of times. But, you know, I think part of it is personality. And certainly Thomas has never really wanted to engage in that way. But I don't think it's truly significant. Going back to my attitudinal theory, you know, his views are his views. So, yes, ma'am. Oh, I'm sorry. You want to direct the traffic then? Oh, she has a microphone, so she's in charge.
That's the power. Thank you. Could you say something about the evolving standards of decency in the context of capital punishment and the possibility that it being overturned on an Eighth Amendment challenge in the near rather than far future?
Well, there's been some evolution in the case that a number of justices on the Supreme Court, the most prominent is Justice Breyer, have questioned whether the technology that presently exists, these multiple drug infusions, you know, work in a way that minimize the pain and suffering of the person being executed. And there certainly have been, in California, at the district court level, you know, justices saying we're going to suspend executions because of this concern. It obviously varies from state to state. Capital punishment is a state issue. Some states have it, some states don't. Most of the states that have it and use it quite vigorously are in the South, we know that. And they continue to do so, but they have been, to some extent, slowed by these drug issues. And then some of the drug companies say, we don't want to give you the drugs. So these are kind of, you know, there's a sort of, in some sense, a political public opinion dimension to all of this, depending on the state. My guess is that in the near future, it's not going to be overturned because of the makeup of the court. And, you know, there's always the hard-nosed person who says, look, you're going to be put to death. Why should we worry if you suffer for 5 or 6 minutes while this is going on? If you want a quick, painless death, firing squad. But those norms have changed, right, in our society. So I think this is one of the areas, actually it's a very good question, because it's an area in which sort of public norms, what people think of as cruel and what's right, you know, will filter in and judges pick up on it. Yeah, you have the mic, you're in charge.
I've been bemused by the issue of originalism. And I'll phrase the question this way, answer it any way that you think is appropriate. And I have never been quite clear as to whether people who invoke originalism are really do apply original notions, or whether it's a way of supporting their political beliefs.
Well, I would say among the serious, and I think Justice Scalia is probably the best example of this, looks not so much even at original intent, but at the text of the Constitution, and argues, the argument there is that, we need to interpret the Constitution by what it said at the time and what was thought of at the time. And I think it's a pretty influential point of view of judicial interpretation, because it gives some sort of foundational element to making up your mind, right? Rather than kind of a more open-ended point of view. But of course, it is also used to support positions that you want to reach. So I think there's a combination of the two. I think that Scalia was quite successful in getting many people to sort of take that as a serious theory of constitutional interpretation and to use it. But it's hard to be consistent in that way. And so the rival theory is sort of associated with Breyer, which is called living constitution, or active constitution, which basically says, the founders could not have anticipated or thought of the many kinds of issues that were going to come up. The Constitution is deliberately vague in many senses. So the notion that you can just look at the text and decide everything is misguided. So that's kind of where it is. I don't know if that addressed your question or not.
Jack,
yes.
Given that you've created the impression they go into this biased, that the arguments they hear have maybe a little but basically no relevance, is there any relevance to who is chosen and what is written to write what I think is called the majority or minority opinion? Or is it just a vote as a vote?
Well, yeah, you sort of put my argument in maybe its most extreme form, because I think that there are nuances of differences among judges, and I think there is a coalition building that goes on, and even on the same case, you will get sometimes different opinions with the same vote. And so I think who writes the opinion in a close case often is a judgment on the part of the Chief Justice, as who, will this win this person over? Can this person's argument hold water with, the majority that say I want to achieve? So I don't think it's completely just, knee-jerk, we know in advance. For example, in this gerrymandering case, can we be sure of how it's going to come out? We can't be sure. We can be pretty sure of maybe 4 votes on one side, at least 3 on the other. But then I think, there could be arguments, and they could say, okay, let's kind of leave things the way they are, but add some parameters. That's what they've done in the past with the gerrymandering cases. So, and I think that's often done to kind of put together a coalition, and then the assignment of the opinion is often a political kind of act. Like Roberts wanted to write the Obamacare decision. First of all, he was a swing vote, and he wanted to write it because he wanted kind of to craft a completely unique and somewhat different argument. And the others on the liberal side said, hey, we'll go along with anything as long as we get our way, you know. You're the boss, thank you very much. Yes, ma'am.
I got the microphone. Can you comment on the view that since Scalia was a conservative, that a conservative should be appointed to that seat?
Well, I think there's no should who should be appointed. It's not like, you know, you've elected a senator from a particular party, that senator dies, so in some sense the people have spoken, and so you replace a senator with someone from the same party. These judicial appointments are quite different. I think that it's clear that, you know, once Scalia died and once the Republicans sort of stonewalled and sort of then got control of the nomination, that they were going to appoint someone whom they felt comfortable with, they hope, and that Justice, in his various remarks and confirmation hearings, paid obeisance to Scalia, but I think that was just strategic more than anything else. We don't really know all that much about how this new justice is going to, you know, decide on some of these complicated cases. He recently sort of, at least if you believe oral questioning, which you may or may not believe in, you know, asked some pretty interesting questions on a rights of the defendant case, which you would not necessarily have predicted from a Scalia replacement. So I certainly don't think there's a should to it. There's usually a political logic to it. And when you have someone like Scalia who had this big following and was this life-size, you know, figure that has some, you know, that has some weight, I think, but not, there's no obligation whatsoever.
Jack?
Yes.
This gerrymandering case, I believe, is the first one having to do not with racial gerrymandering, but with political gerrymandering.
Right.
Now, I don't believe there are any voter ID cases that the Supreme Court is scheduled to take up that I know of, but the North Carolina case was clearly one that the appeals court said was racial. There are plenty of other voter ID laws that are being challenged, and I believe that those challenges are more on a political basis of, you know, Republicans trying to prevent people from voting who are going to vote against them. So I'm wondering what the arguments would be in the non-racial cases for like voter ID in terms of whether or not it actually prevents people from voting, and how the Supreme Court might look at that if they ever got one of these cases.
Well, I think the line of art, I mean, again, you're asking someone who's not a constitutional lawyer, so I'm going to make all of this up as I go along. Hopefully there's no one here who's willing to get up and say that is really foolish, even if they believe it. But I would think that the two kinds of arguments, one of which actually came up in Kennedy's questioning in the gerrymandering case. One is sort of an equal protection argument, which was the argument made in Bush-Gore, actually. And the second argument would be, I guess, a free speech argument, that by limiting, you know, in a very restrictive way the opportunity to vote, you're somehow impinging on someone's free speech rights. So that's what I think would be the case, would be the kind of argument that's going on. But even in the most of voter ID cases have a racial component to the argument, you know, early voting and, yeah. having an ID, who's less likely to have an ID, a particular kind of ID. And so it's not exclusively on racial grounds, but that's certainly there, and that I think strengthens the constitutional argument, as you were pointing out earlier. But in this Wisconsin case, it's a different case, as you point out. They just say, you've got the situation where 48 or 49% of the state electorate votes Democratic, and they end up with, 2%, 1/10 of the congressional seats, and that's kind of goes beyond the bar of political acceptability. We'll see. Who has the mic?
Back to the Scalia death question.
I'm sorry?
Back to the Scalia's
Yeah.
death question. If that had been a liberal justice who had died at that time,
Yeah.
do you think the Senate would have stonewalled the confirmation?
Yeah,
Yeah.
because it wouldn't have changed the majority as they saw it. I mean, I think they would have been more likely to go along with it and avoid a lot of the abuse that they got. But this was a gamble. Actually, it was a kind of a long shot gamble, because who at the time thought that Trump was going to be elected? But, it paid off for them, at least in the short run. And also what it ended up doing is it got rid of the filibuster on Supreme Court justices, which I think is a good thing. I don't think there should be a filibuster, period. I think it's ridiculous. It's not in the Constitution. It's just a Senate rule that was created at some point in time. Its main function historically has been to prevent civil rights legislation. So, Yes, ma'am.
I'm interested in the gerrymandering decision, and I wonder, as a political scientist, if you have a view of a best formula for drawing these districts, quote, fairly. And second, I have not been able to find a description of the models that are under question, and I wonder if you could just point me or us to a description of those models.
Okay. You email Eric McGee at ppic.org. Eric McGee, MCGHEE, at ppic.org, and tell him Jack Citrin said that you are the world's expert on this. Prove it. For both parts. Well, you see, I think the second part of the question. First part of the question is almost impossible to answer. I mean, how do you draw district lines? You have to, the Supreme Court, after many years, said that you have to have equal population, right, within congressional districts, etc. Okay, well, how do you get that equal population? And people are moving, and every 10 years you have to redraw them. And, inevitably, you can do it in ways that advantages one side or another. Is there a completely neutral way of doing it? I really don't think so. I think the norm in California, when we had our redistricting commission, put up to overcome the complete Democratic gerrymander that had been in place for all these years, they talked about compactness as one criteria. So, argument being the people who live close together confront similar problems, and therefore, should sort of be represented or have the opportunity to be represented in the same way. So that's maybe one criterion. There's certainly, as as I think George Lavender said earlier, this constitutional prohibition against sort of racial discrimination, but that has worked in two ways. One way has been to create, to create districts by packing in minority voters, and so that for certain we'll get a minority representative, but in some way lessen their overall impact, right? That's been the Republican strategy in some sense. Should that be illegal? And if so, what are the numbers? It's really pretty hard, and courts have struggled with it actually, because many redistricting plans have been thrown out, usually on racial discrimination grounds, and then the courts have gotten into it and redrawn it. But one of the things that's always true is that incumbent legislators want to protect their own. So most redistricting plans, whoever does them, has a component of protecting the ends of both parties. So is that right? So, one alternative would be to shift from our electoral system to a proportional representation system. That would require a constitutional amendment. That's not going to happen. Both major parties live in fear for something like that to happen. But then if you just say, okay, here's the state of California, and however many parties there are, and we just allocate the vote in that way, as they do in France, as they do in many European countries, that would get around redistricting. Now you can't redistrict a state, right? So at the state election level, there's no gerrymandering. It's only at congressional legislative level. Yes, sir.
Well, this question calls for a fair amount of speculation. 3 points. One is the recent pardoning of Senator Arpaio. The second is the implications of the continuing Mueller investigation.
Yeah.
And the third is the visible arc of the behavior of our current White House. A number of commentators are starting to use the expression impending constitutional crisis. Do you detect such a thing?
Okay, let me take the three questions sequentially. The pardoning of the sheriff is small. It's sort of, you may not like it or dislike it, but it's small potatoes. And a judge just said this is within the power of the president to do. I mean, Clinton supported pardoned this guy Mark Rich because his wife had given, tons and tons of money to the Clinton campaign. He has the power to do it. The power of pardon is basically unlimited, so I don't think that's much of an issue. Your second point had to do with Mueller. Well, depending on what Mueller finds, yes. I mean, I think if Mueller finds that there was collusion between the Trump campaign and then Trump knew about it, and that violates, laws, that could become the context of criminal charges against the president or even an impeachment. We know from Nixon versus U.S. and Clinton versus Jones that a president can be prosecuted on criminal charges, so that is out there, and that would certainly be a crisis. Then the third point is, are we heading for a constitutional crisis or not? I think that, one of the things that I would look at pretty carefully is how long are people, good people, intelligent people, responsible people, thank God, who are now serving in the administration, going to stay there? Is he going to be abandoned by his Secretary of Defense, Secretary of State, and so forth? Because that creates kind of a different sort of situation in a way. I don't know whether it becomes, what the impeachment phenomena is, but if he's unable to govern in any way, then we have a kind of a major crisis on our hands, regardless of the legal side of things. So yeah, listen, don't get me going on, him. But, I've always been someone who said you hope that the president, whoever she is or he is, honors the institution, and therefore even the losing side will, like it or not, gives legitimacy. But of course, his conduct is a challenge to that sort of goodwill. It has been from day one, so, there are many things to worry about. But I don't think pardoning the judge is a big deal. Maybe you disagree, but it is. They choose the people they want to pardon for multiple reasons. In this case, it's a political kind of act of, I said I'm against illegal immigration, he's against illegal immigration. Why are you punishing this guy? That was kind of what the background there is. Yeah.
I have kind of a follow-up question. Given that we have a Congress that's in stalemate, hasn't done much, a White House that hasn't done much and is in chaos, what do you think the role of the Supreme Court is going to be in helping this country maintain government?
Well, just a political observation first. The interesting dimension to this current situation is the fragmentation, if not disintegration, of the Republican Party. Because if they were unified, and if Trump were really a Republican, if he were anything other than a Trump, they could get things done. They got the Supreme Court justice through. That was the one act that they did. Okay, I think the role of the Supreme Court, and let's hope that it is not a partisan kind of phenomenon, is where there are, where the Constitution is being breached or challenged or let's say breached by Trump's actions, that the Supreme Court will step up and say, this is unconstitutional. I think that is its role right now. I think, yeah. And, one has to hope and trust that regardless of their feelings about Trump or about specific policies, that they will act in that way. Now, this breaching the Constitution is a pretty slippery kind of idea. But nonetheless, there are obviously some clear-cut instances thereof. So that's my hope. Yes, ma'am. Mike.
Yeah.
Okay, you're next, I guess. There's someone who has the mic.
It's kind of believed that the right wing has had a well-financed, starting 5 or 10 years ago, strategy for attack on or to win favorable rulings that support whether Hobby Lobby, Citizens United, etc. Do you believe that it's true that the right wing has had this strategic plan and is carrying it out? And does the left wing have a similar think tank, long-term strategy, make the argument, find the defendants, file the case?
I would say that both sides are primed to do that. I would say that the right wing has won on a couple of big cases. Citizens United, you mentioned. The gun Heller case is a sort of a different version of that. It wasn't financed in the same way by the same people. There was a kind of a NRA, of course, which is heavily financed, but I think there were multiple factors that went into that. But yes, I think there are well-financed and organized right-wing groups and think tanks that are thinking ahead, that are kind of trying to identify cases that they want to bring. I think on the left, it's been maybe less obvious, but certainly the attacks on voter ID laws that George had mentioned earlier. I think gay rights is an example of that. So I think the right, that's one of the reasons why conservatives are often so unhappy with the Supreme Court, because they say, hey, we're in control supposedly, and why don't we win every case, you know? What's wrong with this guy O'Connor? This woman O'Connor, and what's wrong with Kennedy? Why did they sort of, fudge? So, but it's certainly the case that there is a network of think tanks and big donors on the right. But, most of the major foundations who you're going to think of, Carnegie Foundation, Ford Foundation, MacArthur Foundation, and others, are really liberal and left. Now, maybe sort of judicial action is not part of their dominant strategy at this point, yeah. And also what we have now, and the Republicans started this, but the Democrats have picked up on this, is attacks on federal law by states. So you have these lawsuits filed by state attorney generals to protect Obamacare, climate change. Used to be on the other side, right? The Republicans filed all these suits against Obamacare. So I think going back to my very, very first point about the judiciary now has become an arena in which all of these political battles are being fought out because they can't be settled at the level of politics because of how divided and how closely divided the country is in the political realm. Go back to the New Deal or the Johnson era, where Democrats had this vast majority in Congress. They could do what they wanted. And then they appointed the judges to say that's okay. But we're not there now. Yes, I think someone else. Yes, you got the mic.
I got the mic. So we live in a country that was founded on the basis of setting up checks and balances on the three branches of government. At least that's what we all learn in Political Science 101. What do you think are the checks on Trump at the moment when he seemingly is threatening to go to war with North Korea? Is there some way we can stop that?
Well, to get a formal declaration of war is one thing. If he were to order an attack just on his own to enter into hostilities, I think it would have to be in response to some kind of obvious act or threat against the U.S. that would be accepted, would be plausible. I mean, we have a War Powers Resolution Act that was passed in the Nixon era, which sort of controls the ability of the president to undertake hostilities without a declaration of war. But of course, if there's a nuclear exchange, those kinds of rules will no longer apply. So I think, one of the constraints is, will he be obeyed? Right? Will he be obeyed? usually the commander-in-chief is obeyed. So I think, we've had many, many instances, forget about Trump, going way, way back, of presidents engaging in war without a formal declaration of war by Congress. So, yeah. I mean, the atomic bomb was dropped without any specific command, right? We were at war. Truman made the decision to do it. Some people approved, some people disapproved. So I think in a situation where you're at war, the commander-in-chief, really has pretty much no formal restraints. But when you're not at war, then to take that action is without some kind of congressional approval is difficult. Now, is he someone who would do it? He's a different animal. So let's say that the probability that he might give that order is higher than anybody else whom we've known, but then would it be obeyed? This is all the realm of speculation. Let's say the North Koreans shoot a missile and it lands on Guam. Okay? Then what? Then probably Congress would authorize a response or declare war. So, at this point it's not Trump who's shooting the missiles. There are lots of very difficult decision, actually, if you're president, is how do you respond to this? I suppose the emerging consensus is there's no good option, so kind of live with it, situation, and hope for the best in North Korea. And maybe that is, the right thing to do. Certainly a preemptive strike would have tremendous collateral consequences. Some people say, okay, the next missile they shoot up, let's shoot it, we can shoot it down with anti-missile defense. Of course, that's good if it works. But if you miss, then they say, oh, you're a paper tiger. Your defense system doesn't work. So, and we're not the only people involved. I mean, they're firing these missiles over Japan. So the Japanese, which have a phenomenal no nuclear weapons, no war constitution, I think that's not going to last very long. So this is a pretty complicated situation. Him shooting off his mouth, of course, doesn't help at all. But even if he didn't say a word, still a difficult situation. And, we've had, from Clinton on, three presidents who've tried to grapple with this situation, negotiation, threats. During the Clinton administration, they actually did debate a preemptive strike and talk about it. In fact, the Secretary of Defense at that time recommended it, but they didn't do it. So this is a really pretty complicated situation, and obviously one has got to be worried about some kind of wild action, but I think it's naive not to think that the North Koreans pose some kind of threat to the surrounding area. Yeah. Any more questions? Someone has a mic?
Trump's ability to pardon himself has been floated by the White House, which seems ludicrous to me. But political commentators take it as a serious question to consider. Could you talk about that a little?
I don't know the law there, but if the law is that he could, my guess is he would. I'm sorry, I just don't know the law. Certainly Ford pardoned Nixon, you remember? That's not like pardoning yourself, but it's like pardoning someone pretty close to yourself. Well, I mean, I think it's either legal or illegal. I mean, there must be an answer to that. I wish someone here could answer it. But you know, as Louise said, I'm a political scientist, not a professor of law, so I'm going to plead ignorance. Not the fifth, but just ignorance. But I will say this, if he could do it, and he did do it, there may be no recourse except, you know, more egg on his face, but he has so much already, I don't know where it would fit.
I wondered if any of the stable Western democracies have institutions comparable to the Supreme Court, or are we an exception?
I think we are being imitated by countries. I think the US had an unusual political system with the separation of powers. Most of the other democracies were parliamentary democracies, where what Parliament said went, and they didn't have written constitutions. But I think over the last 50 years, other countries have moved to follow us. That's certainly the case in Canada, where they instituted a Charter of Rights not that long ago, equivalent of our Bill of Rights. So now the Canadian Supreme Court has the same kind of authority and is subject to the same kinds of criticism of being too political or too liberal or to this or to that. Israel is another country where the Supreme Court has emerged as a powerful, and even in Britain and in some European countries, the constitutional courts have emerged. So I think, if anything, we have been a model, or kind of, yes, a country in which the role of the judiciary or the role of the constitutional court has been emulated by other countries.
Well, I've just been handed the microphone, which means that our time in this room is up. But I hope that there was a long lapse of time between the time when you, the subscribers, asked for a program, a series on the Supreme Court. It has taken a long time, but I hope that after hearing Jack Citrin, as well as Jesse Chopra and Amanda Tyre, you think that it's been worth the wait.